Okay, we're just going to get started in a little bit. Welcome to everybody. I see a whole bunch of new people, so that is awesome. I'm going to ask you to put your questions in the chat. Go ahead and put, wow, we have record attendance. We're always about records here at CCA of A. We had 62 people registered for this webinar, so I love the fact that we've got 62 people willing to take 20 minutes out of their day to join us. So I'm going to get started because we've got a lot to cover. And first of all, for those that have never met me or I don't know you, um, feel free to say hi to me in the chat. My name is Annette Wagner, and I have the pleasure of being the Executive Director of Commercial Collection Agencies of America. This year, we are celebrating our 10th anniversary, and boy, we are doing it right. All year long, we have had different events for our members, and which will culminate with our 10th anniversary conference in Delray Beach, Florida in November. So if you are not registered to go or your company is not registered to go, please visit our website, and I'll put all that information in the chat when we get started. So, and we're looking forward. Some thought it might not work for 10 years, and I got to tell you, we are thriving 10 years later. A lot of people to thank for that, including our board, who is the head of our board right now is our president, Umberto Matz. Umberto, give us a wave, please.
Hi, everyone.
Good. I'm going to turn it over to Umberto to introduce our speaker in just a minute. I want to tell you some late breaking news about the state of California. And I can tell you, I will brief you on this. And then what we are going to do is we are going to have two representatives from the California Collectors Association speak to us. Most likely it'll be next week. But you will all get information on that. And what those two individuals will do is they will delve deeper into the legislation, the law that is now passed, and they will, but I'm going to give you a brief. California enacted what is called SB 1286. And what SB 1286 does is it expands the Rosenthal Fair Debt Collection Practices Act, which many of you don't know, that was enacted in 1977. It to cover commercial debt owed by specific types of debtors. So this bill adds what the language is called covered commercial debt to the Rosenthal Act. So they're subjecting persons that engage in debt collection related to a covered commercial debt to the Rosenthal Act. Now, what we can tell you is, and I'm sure our speaker will comment on this as well, is that from the regulation side, it says, okay, they are just extending what they call UDAP, which are the fair and deceptive the unfair and deceptive abusive acts against debtors. They're doing now that they're pulling that into commercial, right? But also giving the authority from the AG's office to the state agency. That's not really what people are upset about. They're upset about what is going to happen blurring those lines between commercial and consumer. And that's where we are going to be able to have the California Collectors Association speak to us. So if you know about Rosenthal, it says that it prohibits debt collectors from engaging in unfair and deceptive acts or practices in the collection of consumer debts and requires debtors to act fairly in entering into and honoring those debts. Okay, this bill will recast those provisions to expand the scope of those provisions to additionally prohibit debt collectors from engaging in unfair and deceptive acts and practices in the collection of covered commercial debt. And I can tell you, I spent most of Friday with the California Collectors Association and our licensing strategist pulling apart this piece of legislation. And in some, they tried to make a carve out in some of the provisions. Um, that's not really, it's not effective. And I will tell you that um, there are a lot of people that believe that this is going to cause a lot of problems in that not only does it increase the noticing requirement, but where is it consumer and where is it commercial? There are personal guarantees out there. There are the laws of consumer credit are much different than the laws of commercial credit. So look for that is a briefing of what is happening. The governor has 9 more days in which to sign it, but he doesn't even have to sign it. The only way that this bill is going to stop is if there is a veto. And from all the people that I've spoken to, we don't think that a veto is imminent. We don't think that that's going to happen. So the blurring of the lines between commercial and consumer is what keeps people like me up at night because, I play in the commercial reindeer games, and I really have liked it for 30 years. So I don't want to bore anybody, but it is something that is very much on the forefront, and we will get more information to you, and you'll see something go out to everybody who's registered for this 20-minute talk. We'll get another invitation for that 20-minute talk. Okay, that's enough out of me. I'm going to turn this over to Umberto Matz, the Commercial Collection Agencies of America president, who will introduce today's speaker.
Good afternoon, everyone. Thank you for joining. We definitely appreciate the participation, and especially to Matt. Thank you for putting this on for us. So Matt Garcia, as I'm sure everybody knows, is the managing member of Barnett and Garcia, a graduate of the University of Texas at Austin School of Business and School of Law. Matt brings his sense of business to the practice of law. For over 20 years, Matt and his firm have prosecuted and collected on thousands of cases. Matt is admitted to the State Bar of Texas and the Western and Eastern District of Texas. He currently sits on the board of directors for the Austin Bar Association and Texas Creditors Bar Association. Matt is passionate about debt collection and is a frequent speaker on various topics regarding credit, collections, and judgment enforcement. Matt recently served as president of the Texas Creditors Bar Association. He currently serves as the secretary of the Texas Association of Turnover Receivers, is an editor of the State Bar of Texas Collections Manual, and is counselor to Robert Calvert Inn of Court. He recently served on the Board of Governors and recording secretary for the Commercial Law League of America, and Matt is an affiliate member of Commercial Collection Agencies of America and is its Education Committee's newest members. So everyone, please welcome Matt Garcia.
Well, howdy, folks. Good to see you guys. And thank you so much for coming. Hopefully, I'll have some good information to share with you. And before I start on what today's topic was, I just wanted to take a step back. So much of what's going on in California, though, is stuff to get excited about, because I do think that they are creating traps for us. But remember, even in the state of Texas, when just because the FDCPA doesn't apply, or just because the Texas Collections Practices Act doesn't apply, because we're dealing with a commercial claim, that doesn't mean that you can do unfair, deceitful things. I mean, and I think that's why so much of this stuff gets passed, right? Who wants to say, no, we want our collectors to do unfair and deceptive practices? That sounds like a good idea. Doing things that are wrong, harassing people, defrauding people is bad across the board, and you don't need a statute to tell you that. You just need to act like a good human being. And there are common causes of action probably in almost every state that says you can't misrepresent things, you can't harass people, you can't threaten people. And so long as you stay above board, you shouldn't have any trouble. Unfortunately, in California, it really is all about creating some traps. But that's not our topic for today. Our topic for today are dead armadillos on the side of a Texas road. So I don't know if you guys have armadillos. We got lots of armadillos in Texas. And I don't know if you've ever stopped to investigate a dead armadillo or not, but sometimes when you pull over to see whether it's dead or not, you realize, crap, it isn't dead. It's like alive, or it's still kind of moving around. It's just kind of stuck. And so much of collecting debt sometimes can be kind of that way to me. I have a file and I think it's dead. And I go to investigate it one more time and I take my stick and I poke at it. And before I know it, it's back on four legs and it's looking pretty hungry and I'm looking pretty tasty. And I better get out of the way of one angry armadillo. And that's what I wanted to talk about. 4 or 5 scenarios, ideas for you guys to think about that maybe the file that you have on your desk isn't so bad and isn't so horrible as you think it is. And one of those examples is the dead debtor. Lots of times you may get a report from an attorney, or you might be doing your own investigation, and you realize that the debtor is dead. And so if the debtor's dead, who probably guaranteed the debt, and the debtor is the only one who owned the corporation, you probably think the corporation is probably dead. So why even waste your time, right? We're just creating a lot of work for a lot of folks. If you send the account, then you've got to follow up with the attorney to see if they got an acknowledgement or what have you. And so, perhaps the easiest thing to do is just to provide a copy of the obituary to the creditor and move on. And maybe so, maybe there's nothing wrong with that, but there are times when a dead debtor is actually better than a live debtor. And why do I say that? In Texas, as many of you all know, we love to give people exemptions. We get super excited. We apparently don't like to make people pay their bills, and so we say everything is exempt, from cattle to fowl to Bibles to dresses to heirlooms. It's all exempt. And it seems to me sometimes that if something's not exempt in Texas, it's because the legislator just forgot to do it. And so rest assured, every 2 years, they like to add to our exemptions. And so with that backdrop, sometimes being a live debtor is good because they get to keep stuff from me so that I can't use it to try to get you a collected judgment. But once the debtor dies, the exemptions die with the debtor, generally speaking. Homestead works a little different. But if the debtor doesn't have any secureds or any major encumbrances, once the debtor dies, everything goes in a pot and gets liquidated and eventually sold, and now there's a pot of money to pay you. And we had a situation recently for an agency where we learned the debtor had passed away. We searched the probate records and we found an open probate. Like bankruptcy, in probate, you have to fill out schedules of all the assets that the debtor has, and you get some information about liabilities. And if you add up all the assets and subtract all the liabilities, if you've got something left at the end of the game, there may be worth the time to put a claim in. And the cost of filing a claim is $50. So we went ahead and put in our claim for $50. That was the cost of filing the claim. The claim was for much more. The forwarder decided to look and see what other accounts they had. They found 2 other accounts that were not eligible for legal, but they were able to get the client to get those accounts eligible for legal. And we ended up recovering $35,000. not bad. Not when you thought the armadillo was up on four legs, but it buys you quite a couple of hamburgers. We would have only gotten 15,000, but we had a forwarder who was pretty savvy and decided to go peddling for accounts that were in their, not necessarily in their queue, but in their neighbor's queue and in other queues. And so they were able to turn a $15,000 event into a $35,000 event, and everybody walked away. Does it happen all the time? No, it doesn't. And in fact, many of the armadillos on the side of the road are dead. But from time to time, you get one that's got a little bit of life in it. Another armadillo that I see sometimes in my office are cases where a client will report back to me and say, I went on the website, on the comptroller's website, Matt, and I see that the business is forfeited. Therefore, why are you wasting any time? And forfeiture is a good example of another armadillo that is legs up, but definitely is still kicking or has the possibility of kicking. What does it mean when, at least in the state of Texas, when a business has forfeited its corporate charter? In Texas, it only means two things. It means they either didn't file their public information report or they owe taxes to the state. And that latter shouldn't surprise you, because once a debtor, always a debtor. If they owe money to you, they probably owe money to everybody, and the state's probably just another person that they owe. So it doesn't mean that the business is closed. It doesn't mean that the business doesn't own property. It doesn't mean that the business doesn't have an operating account. It sure the heck doesn't mean that the business is defunct. All it means is that the debtor is not doing what they're supposed to be doing. But here's the rub, or here's something that we can do in Texas, and this is where I think it becomes more important. When the business doesn't pay its tax or doesn't file its public information report and goes into forfeited status, on that day of forfeiture and up until it reinstates its charter, the individual officers and directors of that debtor business are now jointly and severally liable for any debt that's incurred during that time. So you might have a debt against ABC Corporation for $10,000. Your creditor, bless their heart, didn't decide to get a personal guarantee. So you look up on the comptroller's website that you see that the charter is forfeited. You shouldn't rush to close the account or call the attorney and say, I think you're wasting your time. It might be an opportunity. And what we know about the more pockets you have to go after, the greater the chances are you're going to make a recovery. So forfeiture is another great example of how a business who might be struggling, if you can show that the debt was incurred after forfeiture but before reinstatement, you actually might have a better opportunity to collect, because now you not only have a cause of action against the company, but against the individuals as well. So, so that armadillo that you see on the side of the road looks a lot more tasty than, say, the other one that you passed just a few minutes ago that looked a lot more plump and bloated. I'm going to stop here because we talked about probate and forfeiture. Does anybody have any questions about probate or forfeiture before I talk about two other quick topics on dead armadillos?
I don't see anything in the chat, but I would call on anybody who wants to just unmute yourself and ask a question.
So I have a question, Matt. So if someone has opened themselves up to personal liability, so typically if we have a claim against a corporation, obviously we can't run credit against an individual, but now that they've opened themselves up, do we now have a legitimate purpose to run the individual's credit?
That's a great question, and I don't know the answer to that question. I mean, I would think not because unless I'd have to look at the choices, but this isn't a situation where somebody's giving you authority to run credit, and I think that's mostly how you guys pull your credit reports. But if you have an investigative reason to pull credit reports, then I think you would because they are liable. There are ways that they can avoid being not liable, but the presumption is that after forfeiture, but before reinstatement, you're stuck. And again, reinstatement doesn't put you back as if it never happened. The statute actually reads you're liable. Some other areas that you all want to think about where you can multiply defendants is the people who write you hot checks. In certain situations, based on how the check is drawn and the person who is signing the check might make themselves liable on a debt that was not a individual debt at all. So for example, you might have, again, ABC debtor corporation ends up with a debt for $45,000, and our nice Susie Q credit manager forgot to get a personal guarantee. And the debtor, Dan, calls up and says how much, writes a check out of his personal bank account and sends it over for $15,000, and the check bounces. You now have a potential claim against Dan the debtor in the state of Texas. Some people have asked about treble damages. That's not something that we routinely get, but you can possibly get a good cause of action against the individual on the hot check, which would be a pressure point that you didn't have before. Now, hot checks have a shorter statute of limitations. So if you see a hot check in your file, you want to find out what the statute of limitations is for hot checks in the jurisdiction that file is going to. But that might be something that you might want to point out to your attorney and say, hey, does this give me any additional pockets? Is this a pressure point that I can exercise? And you'd be surprised at what you might be able to do, especially if the company is either struggling or completely closed. And so I noticed that I'm now at 20 minutes. And so, Annette, I don't know if
I
I'm
have a question. I have a question. We can go a little bit longer. I have a question. Back in the day when I sat on a legal desk, if a debtor wrote a bad check on a COD delivery in the state of Illinois, this is back in the day, so I don't know if it's the same now, on a COD delivery, and the check was returned due to insufficient funds, then the person who signed the check became personally liable for that.
Yeah, that's what I'm talking about. The
Yeah,
person
that's
who
what
writes the
so in
check,
Texas too, huh?
you're multiplying defendants. And
I
and
mean,
and that's the topic of today's thing is as we're in an environment where it's getting harder and harder to collect because of exemptions or because of the mood, we have to figure out, how to creatively get more money out of the files that we have. And a hot check is a good example because you might have a debt squarely against a corporation that's intact, not forfeited, in good standing, struggling, maybe about to close, or maybe it's gone. But now you've got individual liability because somebody wrote a hot check out of their individual bank account.
yeah, yeah.
Can I just say something regarding Matt's, the examples he used? I just wanted for the record, ABC, as far as I know, doesn't owe anybody any money.
Oh, that's right. Sorry about that, Bob.
For those that don't know, that's Bob Tarnish from ABC Omega. So poor Bob, you've been struggling with that ABC example for 40 some years, huh?
I always use XYZ in my talks.
XYZ. All right.
Yeah, I have another quick question, Matt. Can you touch upon interest, what we can demand in interest, what
That's
what
a
are the
great
rules in
question.
Texas?
Yeah, so that's a really, really good question, and it's a very complicated question. Um, but I will try my very best to answer it. And here's the general legal principle. If it smells like a duck and quacks like a duck, it looks like a duck, then chances are you're not looking at an armadillo, you're looking at a duck. And that and that's the law on interest. So when you look at interest, interest is the charging of money for the detention or holding of money. And so if something looks like interest and smells like interest, uh and looks like interest, then chances are it is interest. And what opposing counsels try to do is they try to make everything look like interest. You know, they like to put lipstick on a pig and claim that it's not a pig when we all know that it's a pig. So late fees, collection costs, attorney's fees, liquidated damages, late fees, opposing counsel will always use it as an opportunity to say, no, this isn't a late fee, or this isn't a penalty, or this isn't a collection cost. This really is just interest. And we're using a different title or a different categorization to say that it's not interest, and therefore um, it's not usurious. And that's what you're worried about. Usurious interest is something that is not allowed in any state. What is usurious differs from state to state. And the things that you want to look at are, is there a choice of law provision in your agreement? And in that particular state, is interest considered substantive or procedural law? And so in Texas, if there's a choice of law provision, I go to that state to figure out what is a legal rate of interest that I can charge. And so long as I'm okay in that state, then I'm okay in the state of Texas. If there isn't a choice of law provision, then I look at Texas law to tell me whether something is usurious or not. If there is no rate of interest in the contract, so long as I don't demand more than 6%, I have not committed usury. If there is a rate of interest, and if it fits, and if the type of debt fits the definition um, of the traditional statute, then you can charge as much as 18%. Most of your contracts have what's called a savings clause, and the savings clause says, you know, the interest rate is going to be 24%, or the maximum amount of interest, as you know, that can be charged in your state. And so you wouldn't charge the 24, you would charge the 18, and then you would be fine. So it's a fact intensive inquiry, and you really have to delve into the agreement or the credit application to determine what that is. Texas imposes another requirement in that the interest rate uh, has to be agreed to in writing and signed by both parties. You can't always get the higher rate of interest if you just simply put on the invoice um, net 30, and if you fail to pay 1.5 per month. There should be an agreement, such as a rental agreement or a credit application, where the default says if you don't pay net 30, it's 1.5 per month, and then there's a signature on the debtor. So you're looking at a number of different things, and then once you determine what those are, then you can determine what you can charge and what your demand letter sets out. In the commercial world, I think what we do because we handle volume, is our letters always have the principal balance on the demand letter, and we say that that balance is subject to interest, and for them to contact us so that they can get the payoff balance. And that's typically how we do it, so that we can avoid a usury claim on behalf of our clients. But there are other easier ways that you can implement if you take the time to learn your client's agreements. Does that answer your
It's-
question?
Yeah, it does, but what about, so let's say that the debtor signs an application or a contract, and it does also calls for the debtor to pay cost of collections.
I think you just have to be very clear how you put that in your agreement, so that that way the lawyer on the other side can't use that against you. And so you can ask and demand for collection costs. Whether you actually get them is is a whole other issue. And I think that you can put on your demand letter, principal balance of $10,000 plus collection costs in the amount of 20,000 or 10,000 or whatever it is. Um, but just know that when you do that, an aggressive attorney on the other side is going to try to categorize that as something more than what it is. And you can't stop that. I mean, that's just going to happen. But most lawyers understand what collection costs are, and most courts understand what collection costs are, and it's something that you can demand.
But it's got to be called for in the agreement and
Yes,
signed by both parties. That's super important to understand.
I believe that in order to make a claim for collection costs, it needs to be in the terms and conditions. Yeah. If you fail to pay, you will be subject to principal plus interest plus all costs of collection.
And then I'm sorry, I don't mean to monopolize the questions, but let me just piggyback on that by asking this one additional question as far as, the definition of signing a contract. What about digitally signing a contract? Because we have more and more clients that are doing everything online.
So, we've had lots of conversations with general counsel on this specific topic, because really, if you want to enforce a digitally signed contract, you need to have the metadata, I think that's the right word, behind that signature. If you look at, like, for example, the DocuSigns, you see a bunch of certifications and numbers and IP addresses and all sorts of data. All that data is important in order to validate the signature and that the person who signed is who they say they are. When you don't have that data, you're gonna fail. I mean, listen, we have a hard enough time trying to get the judge to enforce a signature where it's super clear that Al Bundy signed the contract. And yet the judge doesn't want to acknowledge that, much less when Al Bundy gets on the computer and clicks a box or signs digitally, and the digital signature doesn't even look like what he normally signs. So you need that data in order to support the validity of the signature. Um, there are some clients, and some very, very large clients, who don't want to spend the money to keep that data. And so they're making a business decision that they would rather take the chance that they're not going to get the personal guarantor or the customer on the hook, because they don't have that signature. And so long as they're aware that that's a business decision and a business risk that they want to take, I'm fine with it. Legally, we can bring suit, but will we be able to meet the burden? I don't know. That's up to a trier of fact. It gets easier when you have a good or a service that's been delivered, because at the very least, you can go after the customer for what they've received, which is of some value. But it gets harder when that digital signature is a guarantor. And we need the guarantor many times to collect, because that's the pressure point, right? That's the multiplication of defendants. So, yes, can a digital signature be enforced? Absolutely. But I believe in order to make a very strong case, you need that data.
All right, thank you. So it's before we wrap up, does anyone else have any questions or anything real quick? All right.
So I
Matt?
wanted to just, oh, go ahead. I just
Oh,
wanted to say a couple of words.
Go ahead. Well, I was just going to say thank you, Matt, because that was really informative. I appreciate that.
It is
Oh.
awesome. It was awesome. We're so appreciative of all that information. And you know, these 20-minute talks, they spotlight different states. So far we've had a number of states. So these 20-minute talks are brought to you by this platform that we call Commercial Collection Training Institute. And that is a part of Commercial Collection Agencies of America. We have 3 collector courses. So if you have not taken the collector course and you want to see your manager, you can take it. If you pass it, you get a great certificate of completion. And also I wanted to mention that we're editing every one of these 20-minute talks, and we'll have them on the website shortly with the speaker's permission. So okay, Matt just gave us the thumbs up. So if we don't have
Matt, was that a
any other-
legally binding thumbs up?
Yes,
Grab the metadata on that.
it was.
Yeah, that is,
Have
yeah,
somebody
we gotta
that
have
is-
the metadata.
But really, you know, the idea for today was just be on the lookout and beware of what's on the side of the road. Sometimes it's dead, but sometimes it's not. And if you have a few minutes, take a look. It might turn into $35,000.
Well, thank you again, Matt Garcia, Barnett and Garcia. Thank you to Umberto Matz, the president of Commercial Collection Agencies of America. And thank you to everybody who has come. We hope that you learned something, and keep an eye on your inbox for additional 20-minute talks.
Thank
All
you,
right.
guys.
Thank you, everybody. Thanks, Matt.
Thank you, Matt.
Enjoy your
Thanks, you
day.
guys.
Thanks, everyone.
Thanks, guys.
Thanks,
Have a great
Matt.
day.
Thanks, Matt.